Good afternoon, Mr. Pitman.
Good afternoon, CJ.
Did I pronounce your name correctly?
Yes, you did.
Okay. How are you?
I'm okay, thank you.
You look quite nervous, don't be.
It's been a long
relax.
day.
You state that you have 2 degrees, a BA and LLB, acquired from the University of KwaZulu-Natal.
Yes.
I just got curious in regard to your LLB degree.
Yes.
You mentioned that you were assisted financially by the Department of Justice.
Yes.
But at the same time, you say your father had been a successful and well-respected advocate. Why would you have needed to be financially assisted by government?
I think that one of the reasons was that I grew up in a family which encouraged you to make your own way. So that was, so for my BA, I got a bank loan. And for my LLB, I got a bursary. And I worked, interestingly enough, in a butchery on weekends as a student job.
But then your dad died tragically.
He died while I was writing my last LLB exam.
Sorry, that's terrible.
At that stage, I was a member of the SRC, and I came out of that last exam to the SRC secretary and a couple of the members there to tell me the sad news. But my parents had been divorced for many years, so I hadn't lived my whole life with him. But after starting to study law, which was his profession, career, our bond became a lot stronger. And then he'd also been involved in politics, and we'd had a connection there. So at least when he died, we had restored some sort of good family relationship.
Yes, sorry for your loss.
Thank you.
So after your studies, you were the department. Well, you owed it. They snapped you up, put you in a position of public prosecutor. But you spent the first 2 years in military service.
So what happened was that because of the bursary, I had to report to the Durban Magistrates Courts on the 1st of December, I think, of the year that I finished my LLB. And I then was employed formally as a prosecutor from that moment. But at the end of December, I was put in a cattle truck and sent off to Pretoria.
And you were there for 2 years?
And I was in Pretoria for what they called a junior leadership course, which was a section of the army that utilized varsity graduates. I became a law officer and then ended up spending the last 14 months in a town called De Aar, which is in the Northern Cape, as the law officer.
What did the law officer do?
It was an ammunition depot. I think it still is. It had a contingent of guards from all over the country who would come every month. A whole lot of guards would come and sit in those towers surrounding the ammunition depot itself, which, interestingly enough, is situated in an extinct meteor crater, which gives it natural protection all around the ammunition depot. And then there are these guard towers. And what we would have to deal with was guards shooting each other, guards driving vehicles into having accidents in vehicles. There was a constant stream of issues that the law officers had to deal with, the law officer, myself. That involved, if it involved a court-martial, it involved catching the train to Pretoria, which was called the milk train, because it picked up milk at every farm that it passed. So the train trip was literally hours, all night and all the next day.
So when you finished your national service, you went back to the department and actually started practicing as a prosecutor?
Yes, I was contractually bound to do that. I was paid as a public prosecutor while I was doing national service. So my contract with the department was in a 4-year contract, the 2 years of the bursary and the 2 years of being an employee whilst doing national service.
So when you completed that contract, you went into the magistracy in 1990?
Yes.
That was not part of the contract now?
No. I did the 4 years that I was contractually required to do. It was just over 4 years, actually. District court and then regional court prosecuting. And I enjoyed the environment. I enjoyed litigation as a trial lawyer. I always have. And I thought it would be in my interests to gain experience presiding, bearing in mind this was all criminal work that I was involved in. Presiding in the criminal courts, and in those days the chief magistrate could just appoint you. And I then volunteered to stay on for another 4 years presiding as a magistrate in the district courts.
Until you decided in 1994 to go and do your pupillage and join the bar?
I had always wanted to, Chief Justice, be an advocate. I wanted to honour the memory of my father. That's why I had done it. I knew I was going to go eventually. And that was the point that was the most sensible for me to make the move.
And you've been a member of the KwaZulu-Natal Society of Advocates for the past 30 years?
Yes.
Doing what kind of work?
Chief Justice, I have varied practice. As I say, I consider myself primarily to be a litigating advocate. And I have had a practice which covers everything from representing people in crime for the first, obviously, 4 or 5 years of my time at the bar. Because of my history in the criminal section, I got a lot of criminal work. So I did a lot of criminal cases. And then I made a point of slowly moving away from that into the commercial and allied field of advocacy. And I've done everything from small helping people with state agency claims to very high profile commercial matters. It's a real variety. I have not specialized in anything.
Do you have are there any judgments, reported judgments, that is, in matters in which you appeared as counsel that you know of?
Yes, there are.
About how many in estimate, or if you have the exact number?
At least, I think some of them I've mentioned in the judgments which talk about where I acted in cases that I thought were significant in my questionnaire.
No, I mean as an advocate.
Yes, no, I'm talking about.
So
I answered questions there about cases that were significant while I was an advocate. And most of those were reported. But there must be 30 or more.
All right. And when did you start acting as a judge?
I was first asked to act as a judge in 2020 by Kruger J, who was the acting DJP at the time, I think, for a 5-week stint. He asked me again a year or so later for a 5-week stint. And then I think about last November 2023, through till about 3 weeks ago, I've done a lot of more acting stints. Okay,
so it's 10 weeks plus 3 sessions.
It was 30 weeks, I think, when I did my application. It's now 35 weeks. 35 or 36. 35 or 36. Now, I stopped a stint 2 weeks ago.
Oh, I see. And what kind of cases were you allocated?
So the JP kindly gave me some time in the criminal section just so that I could see the difference between what it was like to preside in the magistrates' courts and what it was like to preside in the criminal high court. I did a couple of sessions there, maybe 3 by now, 1 in Maritzburg, a couple in Durban, I think, at least 1 in Durban. And for the rest of the time, it's been the civil section. And what happens in the KZN division, both courts, is that when you serve for a session, you get at least one motion court per week. You get, in all likelihood, a full court appeal, one. But if not a full court appeal, you definitely will get at least 1 or 2 or 3 or 4 full bench appeals. For the rest of the time, you are on call to do trials. So for all of the sessions that I've acted, CJ, it's been everything. Motion court. I've just done the first week of recess in Pietermaritzburg, where I did 3 motion court days out of the 5, which covers everything. Trial work, whatever is handed to me, I do have done from commercial to RAF, and as I say, the either full court or full bench appeals.
Right. What would you say? Well, how many judgments have you produced as an acting judge?
I don't have the exact figure, but I'd say about 26 or 27.
All right. Any of them reported?
No, they're not. They're not reported in the South African law reports or the LexisNexis reports, but they're all on SAFLI.
SAFLI, yes. No, I mean.
So they're published but not reported.
Yeah, that is a difference.
Yes.
Yeah. Okay.
Maybe I should add, CJ, at this stage that I set out in my application that there was one of my judgments had gone on appeal. And when I did the application, the result was not yet known. That judgment, the appeal judgment, it was a full court in Pietermaritzburg. I had refused leave to appeal to the Durban municipality on a 30 million rand judgment. I had refused leave to appeal. The SCA granted leave to appeal. That was heard by 3 judges in KZN, and that judgment was handed down on Monday, and the appeal was dismissed. So, to be honest, I'm proud of that judgment.
Yeah, we know the feeling.
Yeah.
That's a good one. All right. All right. I will hand over to the JP to put any questions she may have for you.
Thank you, CJ. Good afternoon, Advocate Pitman.
Hello, JP.
How were your acting stints, both in Maritzburg and Durban? And do you have any preference of the 2 courts?
JP, I really enjoyed my acting stints. I enjoyed both of the courts. I said at the beginning, I may have even mentioned it to you, that I will go wherever you want me to go if I get the job. I live in Westville. I can drive to Maritzburg, or I can act in Durban. Whatever is needed of me, I will do. I did enjoy Pietermaritzburg. It's the provincial division. It's a beautiful old historic building, and I enjoyed the collegiality of the place.
Yes, and I noticed that in your application you have been nominated by 2 senior council women members of the bar, and I think she's senior junior advocate Noko, and it's quite a diverse group.
Yes.
Is that some reflection on you?
I hope it's a good reflection. Annandale SC is someone I've known since my prosecuting days. I think she is an exceptionally bright advocate and someone whose opinion I have always held in very high regard. Gabriel SC has been a friend of mine since she started as an advocate, as she sets out in her letter, and I've always valued her friendship. She's also an exceptionally talented intellectual advocate, in my view. Nono Nako is an advocate who I have known. She was the registrar of the High Court in Durban, struggled her way through that, getting a law degree, and became a friend of mine when I helped ensure that she got a position in our group of advocates.
And I understand you introduced a nursery in your group of advocates. How did that come about?
Okay, so what happened there is my group of advocates has chambers in Mshlonga Rocks. It has an upstairs and a downstairs, and there are about 20 of us. It used to be in town in Salmon Grove Chambers, but the point I'm making is that we've been together, most of the senior advocates, for a long, long time. Since COVID, it's become, I just became very aware of the fact that it was becoming more and more difficult for junior, previously disadvantaged advocates especially, to be able to afford the kinds of rentals that these institutions were starting to charge for the buildings where chambers were situated. And what I thought was, because a lot of people gave up practice as a result of COVID, and chambers became available, what I thought was, an idea I had was to divide one of the chambers up into at least 4 to enable juniors, and my focus was on previously disadvantaged juniors, to make it more affordable for them. And that's what we're doing, and that's what's working. And we've only had previously disadvantaged juniors.
Yes. The next one relates to your age. You will be turning 64 in a few weeks' time.
Yes.
And I must commend you that I have not felt your age in relation to your industriousness. You have worked hard, probably exceeded some of the younger colleagues.
Thank you.
The question that then relates to that, there are 2 actually. One is, will you have difficulties in respecting, you know, in the judiciary and in the legal profession, the hierarchy is a big thing, the seniority. So now we will have a situation where you are 64 years old and you might have a judge who is 49 years old, who is your senior because she's been appointed before you. Will you have any problem in respecting that seniority?
Thank you for that question. And I'm going to answer it directly, but I'm also going to say that in answering it, I may touch slightly on what I will say when someone eventually asks me why I haven't taken silk, which I'm sure is coming.
I stopped myself from asking that question.
Yes. And that is that I grew up in a family where status was irrelevant as an attribute of a good human being. I have the personal philosophy that I'm better than no one and no one is better than me. My philosophy is that we are equal, whether you are a child or a 20-year-old advocate or anybody else, or a nurse in a hospital or anywhere else. I will have and that's how I've lived my life. I will have absolutely no problem deferring to someone who is younger than me. Maybe I should just mention something else at this point, which is interesting. I know that I said to myself I wasn't going to give long answers, I was going to give short answers in this interview, but I'm going to do it anyway. So I'm a self-deprecating person, I know that. I don't blow my own trumpet, I don't like it, I've never been good at it. If I have to do it today, I'll do it, but it doesn't come naturally to me. I went, at your request, to do the aspirant judges course in June. And people who had done it before me, who I spoke to, said to me, "No, you've been practicing for so long, you're not going to learn nothing. Go, but you won't learn anything." I found, I said this to you, I found the absolute opposite. I loved every minute of it. I thought it was brilliantly put on. It was professional. Justice Matopo, who ran it, was outstanding. The quality of the judges who came to talk to us and gave up their own free time, their own time for free when they could have been and should have been writing judgments, was exceptional. And I learned things that I didn't know. had not known before. And it struck me at that moment that no matter how good I think I may be, there's always an opportunity to learn. And I learned there. And if you ever ask me to go on an aspirant judge's course again, or another kind of judge's course, I will leap at the opportunity. I think I've strayed far from the question.
Yes. So the short answer I wanted was whether you would respect those
Yes.
younger colleagues. Yes. Now, the other question relating to age is we have circuit courts, Madadeni, Pongola, Ofra had, that far. And recently I've had one or two colleagues who are about 67, 66 say to me, and they are quite junior, I must mention, say to me, JP, you must consider not sending us to circuit because of age. And I said to them, you are junior, you will go, you have to do your time. Now you are 64, will you have a problem? And this goes in hand with another question where we have younger judges that have smaller children who might not be able to go on circuit because of those needs. Would you have a difficulty in doing circuits even more often than not in certain instances?
No difficulty whatsoever. I am at a stage of my life on a personal level where my children are finally grown up, out the house. Obviously I've discussed this with my wife, this kind of possibility. It's something I did as a public prosecutor, circuits. I have absolutely no problem whatsoever. In fact, I would suggest that someone like myself is more suited to go and do something like that than someone with young children who needs mom to be at home.
Yes. I'm not going to go so much on judgments and your knowledge of the law because I think it's quite clear from the CV that you are quite knowledgeable and because of the number of years on the bench. But there are just two other aspects I want to canvass. And one is relating to the objection about your temperament. What do you believe in your view are good attributes for a judge?
Well, first of all, I have responded to the temperament allegations in full in writing, and I hope at least that the Commission has had a look at those. I'm obviously happy to deal with any further if necessary. Good. I think that, right, integrity is, I think, the most important attribute, and I have it. I do not lie. I cannot tell lies. I hate liars. The second thing is empathy. I think a judge has to have empathy. As a judge, you're not just sitting dispensing judgments in relation to disputes. You're also managing courts, and you're managing witnesses, and you're managing lawyers. And those people often come from very, very different cultural or other kinds of backgrounds. Empathy means the ability to stand in someone else's shoes. So I think it's a very important attribute, and I believe I have it. There are a lot of things that are needed of a judge: patience, calmness. But the last thing that I think the three things that I'm mentioning, the two I've mentioned already, and the third one is a work ethic. I can honestly say, as I sit here now, that I have never worked as hard as I have while I've been acting as a judge. Never in my practice as an advocate have I had to work as hard as I have to keep up to date with the stuff that you and the division has given me to do. So, and I could do it because I have a work ethic which doesn't allow me not to do it. Now I'm going to blow my trumpet. I have for 30 years woken up at 5 o'clock every morning. I get to my chambers, or if I'm an acting judge, to my office by 6, or 6, if it's in Maritzburg, 6:30, and I then work. And if you have a look at the judgments I've attached to this bundle of documents, you'll see that my turnover rate is about 2 or 3 weeks for a judgment, no matter how complicated, and some of these judgments were complicated. And that's because of work ethic. So I think those are the attributes of a judge. Or I think the essential attributes of a judge.
Yes. And then finally, Advocate Pitman, there is that complaint about you probably not having read papers in that eviction matter.
Yes, it wasn't. It was actually a demolition matter.
Demolition, yes. And in fact, I was quite shocked because I had not received any complaint whilst you were acting as a judge in relation to what you dealt with in court.
That complaint had a number of factual inaccuracies. I'm not sure of the motive for the complaint, but the factual inaccuracies are dealt with in my response. It was not a case of two parties being there. It was a case of one party, the advocate representing the relevant municipality, asking to demolish a building that had been built by the owner, an indigent owner, in circumstances where there had been no personal service on the owner. And in my oversight role, as I said in my response, I was not going to grant a demolition order without knowing that the owner was aware that the application was before court. I had read the papers. I picked that up before the matter was called. It wasn't brought to my attention by the council involved. It ought to have been brought to my attention before I picked it up. But that council was very upset that they didn't get their demolition order.
Thank you, CJ. That will be all.
Thank you, JP. Premier?
Thank you very much. I think it's good afternoon.
Good afternoon, Premier.
CJ, I will start with a follow-up question because I had a presentation or a reflection that he believes in himself to be better and no one is better than himself. My question would be then from that one, what's your relationship with your colleagues at work when you believe that no one can match you? You are better than almost everyone.
Yes, the philosophy is in the context of being a human being, not necessarily in the context of the job. As a human being, I'm no better than any other human being, and no other human being is better than me. My relationship with my colleagues is excellent. I've always had an excellent collegial relationship with everybody that I work with.
No, thank you, CJ. I will save the second question, the question, because it was related to the presentation.
Thank you, Premier. Any questions for Commissioner Mtweni? Pitman?
Good afternoon, Advocate.
Good afternoon, Commissioner.
Advocate, how do you perceive the role of technology in modernizing court processes? And what specific measures would you advocate for to enhance judicial efficiency?
I think that's an excellent question to ask a KZN advocate. And the reason why I say that is this. Although I'm a KZN advocate, I have done work in Gauteng. Gauteng has a system called case lines. It is brilliant. It saves trees because it gets rid of the need for paper all the time. So it's a green project. But not only that, it's just absolutely, it works in such a way that everybody who's a party to the litigation is kept up to date about every single thing that happens in that litigation the moment it happens. This is my impression anyway that I've had as a KZN advocate. Perhaps there are counsel from Gauteng who might not agree with me and might have had other experiences. But my experience in the cases that I've had there is that technology is technology that should be used in all of our courts. We, at the moment in KZN, we work with khaki-colored folders of documents. And sometimes you can be presented with a folder of documents that is 3 or 4 feet high, and you have an obligation to go through it. It's not properly paginated or indexed by the plaintiff's attorneys or the applicant's attorneys. You're trying to find out what the case is all about, or why it's in your court in the first instance. I think the technology issue, the technology that Gauteng has, would be beneficial to all of the divisions. So I think that's a good question, and I support it 100%.
No, thank you very much. No further questions, CJ. Thanks.
Thank you, Commissioner. Commissioner Moimang?
Thank you, Chief Justice. Good afternoon, Advocate Pitman.
Good afternoon, Commissioner.
Just one question from my
Yes.
side. I get a sense that you take pride in your period of military conscription.
I beg your pardon that I did better.
You take pride in your service under compulsory military conscription.
No, I don't take pride in it. I don't take any pride in it.
But how you took us through your DR, therefore, that's the impression that you created to me. So the question that I want to pose to you is, at that time, there was a structure called a conscription committee, which obviously was a conscious effort on the part of young white males who resisted the compulsory military conscription, which obviously I think create doubts in our mind as to your conscience at that time. You did not see it necessary. Didn't you see it necessary to join your fellow colleagues who were part and parcel of the end conscription campaign?
Well, thank you.
Well,
Thank you, Commissioner.
Before the candidate answers the question, I just want to place on record that I did not get any impression that he was deriving any joy from the account he was giving me and all of us. He was just, I felt that he was just taking us through a life experience, matter of factly. But go ahead.
Thank you. I think I would like to answer it.
No, do answer it.
I was at university and a member of an SRC that was a left-wing SRC, and amongst the institutions that we had contact with was the end conscription campaign. I tried to stretch my university degree out as long as I could to avoid military service. Personally, I was an opponent of apartheid and did not want to do military service. Eventually, I couldn't stretch it out any longer, and the choices for me were to peacefully object and get, as I recall at the time, a 6-year jail sentence, or go and do it and get it over with. I wasn't brave enough to take the jail sentence, and I'm sorry about that till today, but I wasn't. And I went and did service and got it over with. I was not in active service. I did my basic training in Pretoria at Fort Rekohoogte. At the time I was there were riots somewhere in South Africa, and they came to our bungalow and asked for volunteers to go and help quell riots. Myself and other left-wing members who had been at university with me refused to take part. We refused to go with the rest of them to quell these riots. We sat there. We were treated like rubbish from that moment onwards. That was the best we could do. It was a difficult time with difficult decisions.
No, thank you. I appreciate the fact that we are part of NUSA's activities. Thank you, CJ. Thank you, Advocate Pitman.
Thank you, Commissioner Moimang. Commissioner Nkukaito.
Advocate Pitman, 2 of the objections have already been put to you.
Yes.
But there is one that has not been put by Dr. Ghani,
Yes.
who says that she was once your client.
It's a man, yes.
He was once a client. Yes. And then appeared in another case now as a litigant before you. But you failed to disclose that fact and to recuse yourself.
Yes. That's what he says.
Yes.
So
Well, I don't know if it has been brought to your attention.
yes.
Oh, yes, all right.
I did
You can
respond
answer
to
it
it.
then.
I did respond to
Yeah,
it.
no, we've
Yes.
got your response. Just answer for the benefit of everyone.
Do you want me to say anything more about it?
Yes, that's the objection. So
Thank you.
it says we must ask you about
I
whether you're
see, yes,
suitable
yes.
for judicial appointment, given that this was your client, they appear before you, you don't disclose, you don't recuse.
Yeah.
I mean, obviously you filed against him.
No.
Oh, you didn't? Okay, well, still there was a duty of recusal. But anyway, what do you say?
So, thank you, Commissioner. So, he says in the complaint that he was my client in 2018. I can't remember that he was my client in 2018. But what happened was that I was the motion court judge on a particular day when a matter came before me as an urgent matter of and the names were G.S. Gani and I.S. Gani or something like that. I was not asked to make any decisions in that matter. It didn't occur to me that this might have been a client of mine. There are many Ganis in Durban, and I made no connection on one level or another. I was not asked to make a decision. They were both represented by senior counsel, or at least one was by senior counsel. One might not have been by senior counsel, but by a senior advocate. And a consent order was given to me, which I then made an order by consent. So I wasn't asked to make a judicial finding or determination one way or another. I was simply asked to record an agreed consent order and adjourn the matter. If I had known that he was my client previously, if someone had told me that, I would have, even in the face of a consent order, I would have said to them, are you comfortable with me making this consent order? I would have said to both parties.
Yes. But I mean, the point is not really the nature of the order. The real answer is, well, I'd forgotten if he had been a client. Because if he had been a client, the duty would have arisen anyway.
Maybe. And I say maybe, Commissioner, because as an advocate, the independence of advocates allows you to represent a party in one way on one day and in another way on another day, as long as the matters aren't related, as I understand it.
Yes,
But I didn't. But you're right about one thing. I didn't know. If I'd known that they were parties, I would have certainly investigated whether there was a reason through a connection between the two matters why I should not be involved.
yes. Well, sometimes, you ask a small question and then it gets bigger because of the answers. I thought this was a small question, so I would really like us to close it. The fact is you were not aware that this was
No.
your ex-client.
No.
You're not making any arguments about whether there was a duty of disclosure.
No.
Yes, all right, thank you.
Thank you.
Commissioner Trollip?
Thank you, Chief Justice. Advocate Pitman, just for the record, and I'll be using the record later, was your late father Christopher Pitman's brother?
Yes.
Okay.
My late father was Harry Pitman.
Okay.
Christopher Pitman was always known by all of us as Kit.
Kit, right. When I read the papers, your application, your questionnaire, listened to the JP talking about your virtues, and I read your responses to the complaints. I found it very difficult to reconcile even the people that had nominated you, where, one of them said that you were generous and honest to the core. I found it very difficult to reconcile the allegations that were made by the complainants, and you did respond comprehensively. What do you think the genesis of those complaints were? Were they malicious or?
Are you talking about the demolition, the AFT complaint? Are you talking about the complaints that AFT raised in their... Right. Well, what do I think are the genesis? It's a very difficult question to answer because I really actually
You
have
have to
no idea.
speculate now.
I beg your pardon, Chief CJ? I'm sorry?
Do you want to speculate?
No, I don't really want to speculate.
Then maybe we should not waste time doing that. You don't know.
I have no idea.
Yeah.
But what I can say is that as an advocate, what I've realized as a judge since I've been acting, and lots of people don't really get this, our system of justice is an inquisitorial system of justice, not an acquisitorial system of justice. In other words, there are two teams that compete against each other in court, and a judge is a referee. Just like you get your referees in football matches, and you get your referees in rugby matches. And unfortunately, the way our inquisitorial system works is that there's often a loser. And when you are a referee, sometimes you simply get blamed. It can happen, I've seen it happen. I don't know, I'm not speculating about this case, but it is a possibility.
Have you finished, Commissioner Trolley?
Thank you, Chief Judge.
Do we have questions from the virtual platform?
Yes, Chief Justice.
Please put your questions, Prof.
Good evening, Advocate Pitman.
Good evening, Commissioner.
I think the story that you have narrated is commendable. The one that you spoke about trying to assist advocates from unfortunate circumstances for them to be able to afford their chambers. And I just want to build on that. We have learned, at least today, that there are still very much challenges with respect to the briefing patterns in KwaZulu-Natal, and the black females in particular seems to be, or they are definitely at the floor of the briefing line. What role, if any, have you played in ensuring that, at least in your practice, because you are not the one giving out work, you cannot blame you for giving out work. In your own practice, what role have you played in ensuring that at least you rope in some of those people from difficult circumstances for them to be able to at least get some head start in their practices? Thank you, CJ.
Thank you, Commissioner. The nursery chambers is one way that we have I've managed to cut down costs so that they can make ends meet. As I refer to in my application somewhere, and it pains me to have to repeat it, I paid for a particular advocate's chambers for 3 months because they were not being paid by the state attorney. I have an open door policy. Every junior in my group trails in and out of my chambers all day, every day, because I'm trying to help. I use the juniors from previously disadvantaged circumstances, particularly those that I am aware of who are battling financially, because I administer the group of advocates I work in, and I'm aware of the financial difficulties some of them are faced with because they come and tell me. I use them to devil for me and pay them from the fee I get from the attorney. Those are the kinds of things that I am involved in to try and ameliorate the difficulties that struggling juniors are faced with on a daily basis.
That is commendable. When you do rope them in, do you rely on them in terms of the work that needs to be done? Because there is also that part of the transformation in making sure that they learn in the process.
Yes, most definitely.
No, thank you very much, CJ.
Thank you.
Thank you, Prof. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Advocate Pitman.
Good afternoon, Commissioner.
I just want to follow up on your answer to the question from Professor Marumahai. Did you bring any juniors into your matters as juniors, not as devils?
Yes, I have, but I'm very rarely briefed on the basis that I'm entitled to bring in a junior. So on the occasions that I have, I've paid for it out of my pocket. What I can tell you, though, is that as a judge, I've had a much better opportunity to provide not only the imparting of skills, but some financial relief to previously disadvantaged people in respect of the criminal work that I do. Our criminal procedure provides for assessors. I'm very comfortable doing criminal work. I could do a case without an assessor, but the purpose of assessors is important. One, because by its very nature, it allows for the input of a multicultural approach, so to speak, if you use assessors who are not necessarily lawyers or who are lawyers but are from different cultures. But the second thing is, I have so far done criminal sessions where I've used 2 assessors. I approached the bar for struggling black women who would be able to get experience in a full-blown criminal trial that they might not get anywhere else, and at the same time earn the assessor's fee. Those who I've used. And if I use assessors in the future, those who are the people that I'm going to use.
Advocate Pitman, my question was about juniors that you work with and not assessors that you helped get appointed. Do I understand your answer to be that your practice didn't permit you to bring juniors onto your matters?
No, sometimes, no. Ordinarily, what happens is an attorney will brief me to do something. I will say, can I bring a junior in to help me? They'll say, no, we haven't got fees for that. I then have still brought juniors in, but then I pay for that myself, which I've done. But it's not always possible. And the assessors that I use are juniors. I use juniors as assessors.
I think let's leave the question of assessors aside. I'm interested in the fact that you indicate that not all of your matters are worthy of bringing in juniors. It's not sufficiently big to bring in juniors.
Now, my practice is very big, but the nature of the case will demand whether the attorney will permit you to bring in a junior. And the nature of the client that the attorney has will decide whether the attorney gives you an instruction to bring in a junior. As counsel, you act on instructions from attorneys. You don't tell an attorney that his client must pay for a junior. You can advise it, and I often do. But that's how the relationship between attorneys and advocates work, as you probably know.
I'm slightly familiar with the concept.
Yes. So
Only slightly.
So there are cases where I think I need a junior, and if the attorney won't give me one, I use one of the juniors and pay myself. There are other cases which do not require a junior, and then I won't have a junior.
You see, Advocate Pitman, you've portrayed yourself as a proponent for transformation, but you've indicated now that your matters didn't always require the use of a junior.
Yes.
I just want to then get onto the second issue, which is your conscientious objection to taking silk, or to applying for silk, rather.
Yes, all right.
Has it ever occurred to you that you may be able to bring in more juniors if you apply for silk?
All right. It's not a conscientious objection to taking silk. And I'm going to refer to my family background again. I grew up in a family which held that status and title was irrelevant to the qualities of a human being. Now, that had an effect on my personality. So I started as an advocate, and up until this point in time, I feel personally fulfilled in what I'm doing. I haven't felt the need to apply for silk. Yes, your question is a very good one. If I take silk, I may very well then be limiting myself to the kinds of cases where a junior will be necessary. And in view of the development of the institution of silk, more specifically recently, with solid criteria being laid out for how you get there, I am thinking about that. If I don't get the job as a judge, that's probably the route that I will take.
Thank you, Chief Justice.
Do you have questions, Commissioner Bredenbach? Commissioner Mangen?
Thank you, Chief Justice.
Yes.
I don't have any, thank you.
Oh, thank you. I thought we'd lost you. Commissioner Mangen?
I'm covered, CJ.
All right. All right. You are excused with thanks, Mr.
Thank you very much.
Pitman. We
Thank
have
you very much,
finished the
CJ.
interview.
Thank you, Commissioner.